Всім доброго дня. Вітаю вас в Українському кризовому медіа-центрі. Мене звати
Greetings everyone from Ukraine Crisis Media Center. My name is Vladimir Yavaretsky, Program Director of the Center for Civil Liberties, and we are going to talk about human rights in Crimea and how the implementation of the ECHR decision on Crimea will be implemented. And we also have today the Margarita Sokolenko, Commissioner for the European Court of Human Rights. She will be with us online. Alexandra Pavlichenko, Executive Director of the Ukrainian Helsinki Human Rights Union, and also Mikita Petrovets, lawyer of the Regional Human Rights Center. And we are the team of the NGOs which were undertaking the efforts to implement the decision of ECHR to be more consequent. So on the 24th of June 2024, the judgment adopted on June 25, 2024, was the first of the interstate cases of Ukraine against the Russian Federation, in which the court recognized numerous systematic violations of human rights on the occupied peninsula. And this includes violation of more than a dozen rights, including the right to life, freedom of expression, movement, torturing of the servicemen and civilians, Crimean Tatars, journalists, and also detention. Beside that, violation of freedom, that is detaining a big number of people and secret detention, and also political prisoners, illegal judges and courts which were established, and the judges who were judging according to the Russian laws, lack of efficient mechanisms of appealing, and also lots of violations related to freedom of association and meetings, religious prosecutions, and also religious organizations, a lack of efficient mechanism of refusal from the Russian citizenship, the problem of property deprivation, and also the problem of the right for education, because Ukrainian language is not taught in the schools, and limited movement between Crimean Peninsula and Ukraine mainland, and there are even more problems. But beside that, it's also very important to understand that it relates concerns not only events which happened in 2024, but we are talking about systematic violations, and most of them continue since 2014 till now, and therefore the implementation of the decision of ECHR on these cases matters from 2014, and it is evaluated at the moment, assessed now, till 16 of September 2024. It's when the Russian Federation stopped their obligations according to the convention, but this obligation is still in place until now. So what are the legal consequences of the situation? And so the decision is in place, and now we have to develop the program on how this decision can be implemented. So in fact, we have to fill it in with the sense when it comes to the obligations, Russian liability to fulfill this decision. Of course, the Russian Federation is not planning to do that right now, but let's see what will happen in the future. And on the 6th of March, on the 4th, 6th March, the Committee of the Ministers of the Council of Europe had the meeting, and that is the authority which is responsible for the implementation of the decision of ECHR, and they are the ones who are planning the list of obligations of the Russian Federation. So they started to form these obligations of the Russian Federation, and till now there was a meeting which already happened, and there is a preliminary decision of the Committee of the Ministers of the Council of Europe, which is already forming the preliminary obligations of the Russian Federation. And as for the NGOs, we are representing, that is Ukrainian Helsinki Human Rights Union, the Center for Civil Liberties, and also Regional Human Rights Center. We have sent our document with our vision of the activities which have to be done to fulfill this decision. And therefore, we are now talking about the procedure, and we are going to talk about these activities, these measures, and what can we expect from the future. So now I'd like to pass the floor to Margarita Sokorenko. For a long time, she was fighting for this case in the European Court of Human Rights, because she is the commissioner for the European Court of Human Rights from Ukraine for a long time, and maybe she can tell us more about the procedure and the expectations and what can we expect from the implementation of this decision, because Margarita has a very tough schedule. Unfortunately, she will stay with us only in the first part of the meeting, and therefore we are giving her the word. Margarita, the floor is yours. Thank you very much, Mr. Volodymyr. I would like to greet everyone who joined our meeting. And first of all, I would like to thank Mr. Volodymyr and Mr. Alexander and Mr. Mikita for organizing this discussion. And I'm sure that it's going to be just the beginning, and in the future we will be able to meet again and to discuss the other decisions, interstate cases against the Russian Federation. And Mr. Volodymyr has said that since the beginning, we were working on these cases, but I would like to emphasize that this decision, which we got in 2024 in the case Ukraine against the Russian Federation, that is the great result we achieved together. The team of the Ministry of Justice, which we are working on this issue since 2014, the team of the NGOs, which started working on this since 2014, also the teams of the other authorities in different time, different authorities were joining us, and they were helping us to collect the evidences to support this case and to find the strongest arguments in this case, which in the result were expressed, and in the result we got the decision on this case. And therefore it is so important that considering the fact that this result was a joint, the result of joint efforts of both the state and NGOs, in ECHR, and I'm quite sure that in the future we will undertake the joint efforts from the state authorities and NGOs when it comes to the implementation of this decision. And as for the Crimea, I'm quite sure that it's just one of the first successful case, and we have the other interstate cases, and in some of them we already expect what will ECHR decide considering the arguments we have provided them with. And 1 week ago in the cabinet of ministers of the Council of Europe, we had the first meeting on the implementation of the decision of ECHR for Ukraine, and for everyone of us that is a new experience, because here we are the first time not as the state which is suing the other state, and we expect from the Russian Federation to fulfill their obligations. And it was significant that the Committee of Ministers of the Council of Europe, as Mr. Volodymyr has said, in their first decision have stated the list of those actions which the Council of Europe expects from the Russian Federation on the implementation of this decision, meaning that there is the list of the individual activities and the general activities which are expected from the Russian Federation to consider that the violations are being fixed. And in this case, we have to say that, as Mr. Vladimir has already said, the Russian Federation stopped the communication with the Council of Europe since 2022, and it happened after the Council of Europe has expelled the Russian Federation after the full-scale war in Ukraine. But I would like to emphasize what I'm always saying. It doesn't mean that they have no obligations, both within ECHR. There are the cases which are now considered by ECHR against the Russian Federation, and besides that, they have obligations to fulfill the decisions which were already made by ECHR before the Russian Federation was expelled from the Council of Europe, and also they have to fulfill the decision which ECHR will make till the moment when the convention stopped being applied to the Russian Federation. That is September 2022. And the important moments we have to underline, if we consider the decision itself, it is very detailed. And if we compare it with the decisions on the implementation of the interstate cases, comparing from the other countries, we can see the instructions for the Russian Federation, and we can see what the Committee of the Ministries expects from the Russian Federation. And one of the provision means that they have to return all the political prisoners and also stop prosecution of our citizens. And beside that, it is also important to state what was important for us in both the decision and the statement of the ECHR after the Russian Federation has occupied the Autonomous Republic of Crimea. They have spread the Russian legislation on this territory. And also another thing to mention is that the Cabinet Committee of Ministers stated clearly that, in fact, all those violations which ECHR is talking about, and we are not meaning some single or individualized cases, but we are talking about the existence of the system of the administrative practice of the violation of the human rights, which were already listed in the beginning, and that they are the consequence of the fact that the Russian Federation has spread on the territory of the Autonomous Republic of Crimea and Sevastopol the Russian legislation. And the Committee of the Council of Europe continued the thought of the European Court of Human Rights, state that the violations which are continuing, and that is what we are observing at the moment, that is the consequence of the Russian legislation being spread on these territories, and they urge on the you say that the Ukrainian legislation has to be applied on the temporary occupied territory of the Autonomous Republic of Crimea, and the Committee of Ministers understands it clearly that the Russian Federation voluntarily at the moment is not willing to fulfill this decision, and therefore what is important in the decision as of the 6th of March is that the Committee of Ministers has contacted the members of the Council of Europe in order for them to be seeking for the methods and ways of the implementation of the interstate case decision together with Ukraine. And that is probably the first time when we have the first clear instruction from the Committee of the Ministers of the Council of Europe. And maybe I will tell you something interesting about what was happening during the meeting on the 6th of March. In fact, we have an unanimous understanding and unanimous support inside the Council of Europe and from the members of the Council of Europe regarding Ukraine, and that this decision has to be implemented, because implementation of this specific decision, and I'm quite sure that we will be talking in the future, I hope, about some future decisions as well, that this decision matters not only for Ukraine as a state, but also it is a kind of test on a joint work of the Council of Europe and the efficiency of the conventional mechanism of human protection, which is which was established by the Council of Europe. And as for the future actions on the implementation, I completely agree with Mr. Volodymyr that indeed we have to develop some certain plan of actions, action plan on the implementation. Also, we will be working not only in Ukraine on the measures, because in this case we are talking about the need of engagement of the Council of Europe and the members of the Council of Europe. We will be looking for the mechanism in the Council of Europe. And also another important thing, in the perspective, in the future, it is important for the joint efforts which we will undertake together with NGOs. Mr. Volodymyr has mentioned that there was a contribution of NGOs in this case. And that is one of the important mechanisms when we can contact both from the state authorities and from NGO to inform the Committee of Ministers of the Council of Europe on what is going on the implementation of the decision and what is not being done and what needs more monitoring and control. The Committee of Ministers of the Council of Europe has evaluated this situation, this information very highly, the information provided from the NGOs, the information which was presented by the Ukrainian delegation during the court hearing, and also they supported the suggestion which we can see in the decision that the monitoring has to be conducted permanently, and it has to be the complex, comprehensive one and systematic. And in this case, there is an important thing that this comprehensive monitoring and its results, we have to be the initiator, the driver for the Committee of Ministers to have it all the time in agenda, to have in their agenda the implementation of this decision. That is the first decision, and as well as interstate decisions. So typically, this one is untypical, and also the decision of the Committee of Ministers, comparing to the other cases, it is a bit different from what we've seen before, and therefore, in the future, together with the NGOs, and I'm quite confident that in the future, together with the partners in Europe, we will be working in depth on the activities, and we will be implementing these activities, and gradually we will be able to discuss them in depth, those steps which we are doing and the results. Thank you very much for your attention. Thank you very much. Thank you very much, Margarita. So for the details, for the call for cooperation, and I hope that civil society will hear your call, and soon we will be able to organize some certain events to have the activity plan for this for the implementation of this decision, for this decision not to be forgotten, because this process is very important. It's political, partially legal, and therefore it is important for us that this decision has to find its legal track. There are some obligations which have to be fulfilled, and these obligations cannot be cancelled, even if Ukraine will do something. Nevertheless, ECHR will not be able to change this decision. The decision is a final one, and the obligations are identified, and that is very important because politically, in fact, that makes these decisions higher than any kind of agreements, any kind of processes. So that is the obligation of the Russian Federation. The only thing is that the time when it has to be fulfilled, implemented, and the activities foreseen by these decisions. So I'd like to remind you that the decision of ECHR has a few dimensions. First of all, that is financial side. So satisfaction in this decision will be identified a bit later by ECHR. They have taken a few years for that. And as for the fact of the violation of the human rights identified by this decision, in this case, we can see the general activities and individual activities. And these general activities that are systematic things, they are typically related to the change of the legislation or to the change of some certain administrative practice. When we're talking about individual activities, in this case, we're talking about individuals who are now, for example, in detention and whose property who were deprived of their right for property, or in the other ways their rights were violated. So in fact, we wanted to, when we were forming this document, we were trying to understand what kind of activities should what kind of obligations should have the Russian Federation. And I would like to pass the floor to Mr. Alexander Polichenko, Executive Director of the Ukrainian Housing and Human Rights Union, to explain us what are these activities. So indeed, when ECHR makes a decision and the procedure of the implementation and monitoring of the implementation starts, then under the normal conditions, in this process, the state is present. The state, for example, in this case, that is the Russian Federation, the European Court of Human Rights and the Council of Europe through the Committee of Ministers, and also if it is an interstate case, then Ukraine. And in this case, the deputy ministers, that is the meeting of the Committee of the Ministers, it was stated that the Russian Federation, as the state, refused to work with the court and does not provide any kind of plan of implementation of this decision. And therefore, court undertakes initiative and identifies the current issues which have to be resolved both on the individual level and on the level of the general level. But nevertheless, first of all, what is the most important case here? The first position, the jurisdiction of the euro of Ukraine is on this territory. So that is not the territory which, for some reason, has legally belongs. So that is not the territory which belongs to the Russian Federation, and temporarily it was legally controlled by Ukraine. And the first provision says that, I can quote you, the Russian Federation illegally spread the legislation of the Russian Federation despite the convention of the humanitarian law, and therefore the administrative practice based on the Russian legislation in Crimea cannot be considered legal or the one which meets the requirements of the law. So that is the requirement to recognize the status of all the acts as the ones which are considered to be illegal, and therefore they are the source of the constant violations. So the fact that on the territory of Crimea, it's something that is considered to be a legal decision, court decision, they are recognized as illegal actions of the Russian Federation. And the first requirement is to return, but that is the general requirement, to return Ukrainian legislation on this territory and to cancel the implementation of the administrative practices as they are mentioned, as they are named here, which refer to the Russian Federation. In our documents which we prepared, which was a teamwork in a very which we prepared in a very fast way. We prepared the action plan of the implementation of the decision with a focus on those problematic issues which are the objective of each organization which were named. That is Center of for Civil Liberties, Ukrainian Helsinki Human Rights, and Helsinki Regional Human Rights Center. And in this case, we can see almost direct correlation with those violations which were in the documents which we've sent to the Committee of the Ministers for the consideration of ways of wording which we can find in this document. First of all, the objective is the most vulnerable people, those who are in the detention, who are suffering from the real physical violation of their rights because of the torturing, violence, and that is a priority, and that is identified by the individual activities. And with this systematic approach, which I would like to underline because it's not typical for the decision of this type, first of all, the establishment of the open data basis of those who are now in detention according to the illegal cases. So that is immediate. So there is safe conditions for the people, and namely under Ukrainian jurisdiction. So it means that these people have to be sent from these or temporary occupied territory, or it should be the systematic condition which says that as I would have said, these administrative practices should be stopped. That is what the Russian Federation says. They established the legal control, legal regime. These things have to be changed until there will be the possibility for these people to return. And let's refer to the general philosophy of the implementation of the decisions. The first thing, as it was already mentioned, the individual activities. They have to compensate and to correct the individual violations of rights. The general activities, they have to be the prevention measures to prevent the similar violations. So in this case, we have the combination of both individual and general measures, activities, because these violations are ongoing, and the Russian Federation, unfortunately, is not willing to change the practice and to recognize the fact that jurisdiction of the ECHR requires to undertake the actions which, first of all, and here we have systematic approach, they have to stop this practice, first of all, and second of all, to secure the people who were the victims of this practice, to stop the illegal illegal activities and to provide them medical and other types of support and return. That is also one of the practices and trends of the Regional Center of Human Rights, so the work with those people who were in detention centers on the territory of the Autonomous Republic of Crimea and on the territory of the Russian Federation as one of the types of pressure and violence against these people. And this requirement has the similar wording and returning these people to the territory of Ukraine under Ukrainian jurisdiction or not sending these people to the territory of the Russian Federation. What is new? That is the combination of all international tools and including in the mechanisms the institutions which are investigating the crimes committed by the Russian Federation. That is new for these type of decisions of ECHR. And what is also important, they are mentioning the categories of those groups which are facing the systematic pressure of violating of their rights. Beside the fact that there is the analysis during of the rights, for example, the right for a life, right for not being tortured and inhuman treatment, also the right for privacy, freedom for the rights of meeting, the separate right for owning the property, right for education. And in this case, it is important to understand that they mentioned the group. So non-discrimination approach regarding the Crimean Tatars and also non-discrimination approach to those who have pro-Ukrainian position and who do not belong to Moscow Autokephal Church, and the question of the return of the expropriated property, which was illegally appropriated with the illegal practices, recovering the right of movement. So it means that people are not able to move from the Autonomous Republic Crimea to Ukraine, and therefore that should be the processes. But that's not the question for today. But also it is also important the question of the possibility to refuse from the Russian passport, which on the territory of the Autonomous Republic of Crimea is illegal action and according to the Russian Federation. And it's well spread not only on the territory of the Autonomous Republic of Crimea, but also on the rest of the territories occupied by the Russian Federation, temporarily occupied since 2014 and since 2022. And probably the last and the most important thing is the inclusion of the international monitoring mechanism in implementation of this decision, which I would like to emphasize is done according to the articles of the convention. They have to be under control of the Committee of the Ministers of the Council of Europe, and therefore they have to be controlled. All these processes, they have to be controlled by the international monitoring mechanism, which are also listed. The European Committee on Prevention of Torture. So there are the relevant structures on the level of the UN and ICRC, which also have to join the monitoring on the implementation of these of the decision on correcting this violation and fulfillment of the obligations in the Russian Federation. And let's be honest, the Russian Federation didn't start it. And the fulfillment of the decision, which will be formed with final wording, because this decision, as we can see, is an intermediate one, interim one. Thank you very much, Alexander. And I would like to give the word to Mikita Petrivets, a lawyer of the Regional Human Rights Center. While the NGOs have sent quite a comprehensive list of the activities, and the Committee of Ministers was very careful about. They made a first step. They made a careful step, but even though in some cases it was a very progressive step, but nevertheless, I think that it's a good start. How do you evaluate this rate of what we require and what Europe can agree for? What we suggest and what Europe agrees with in the context of this decision, what they are ready to require from the Russian Federation? What do you think about it? Greetings. Well, that is an interesting thing, because here we have to refer to the document we have sent. And adding to what Mr. Alexander said, we can say that the actions, measures which we suggested, first of all, they were more general, like stop adopt action to release the political activists and prisoners, and also the other ones, for example, prohibition of mid-release or some certain decisions, so according to which the property of Ukrainians was expropriated. And also we were suggesting, which is in fact, it's a pity that it is not reflected in the decision of the Committee of the Ministers, but there is a reason for that. There's a separate block of the development of the compensation mechanism for those who became the victims of these crimes. And if we pay attention to this, then it's worth saying that it is important for us to mention that ECHR, even though not directly, but they say that the human rights violation, they have the serious signs of violation of the human rights, which is not typical for the human rights court, and we were paying attention to that, and we were suggesting to investigate these cases and to punish the ones who are guilty, in case when we can see the violation of the international human rights. And if we're talking to the decision of the Committee of Ministers and how they responded, that it was more careful, because I can say that the Committee of Ministers, they went in the direction of the general activities without some details, which can say that this has to be cancelled, this has to be stopped, and these people have to be released. But that is the matter of the next decision, which will be made on the annual basis, because this process will be ongoing until the moment the Russian Federation fulfills everything. And there might be updates considering the new violations, but nevertheless, if we consider the decision of the Committee of Ministers, what I would like to underline is that when we were talking about the serious violation of the international humanitarian law, they suggest to punish the agents who are guilty in violating administrative procedure, even though they cannot be talking about the serious humanitarian law, but they mentioned a convention. I think that was the referral to the word serious, and the thing is that they just do not want only to punish, but also the management. Because in my opinion, because that is the case when we have to pay attention of the International Criminal Court to show that you are considering the case of the cases which were committed after 2022, but the European ECHR says that there are real signs of the serious violations, and the Committee of the Council of Europe suggests to punish the heads of the state, and maybe to remind the International Criminal Court that it was shown. It has happened in Crimea, and maybe there should be the orders for the rest. And there were lots of sues in the criminal court, and I think that it was enough to consider the potential orders for arrest regarding some certain people, and that would have been a very strong signal, especially for the temporarily occupied Autonomous Republic of Crimea. Beside that, okay, let's slow down. And beside that, what I would like to pay attention to, that we were suggesting to stop using the educational standards of the Russian Federation in the temporary occupied autonomous Republic of Crimea because they have assimilative purpose, and they are preparing Ukrainian children to be engaged in the military actions in Ukraine because they are saying love Russia and fight for Russia. It was important for us, and the Committee of Ministers responded to that, but more generally to return education in Ukrainian language and stop persecution of Ukrainian-speaking children and teachers. So our offer was, so to say, more broader. And what I was telling about compensation, unfortunately, the Committee of the Ministers did not reflect it properly, that there should be some compensational mechanism in place. But I think that the reason is that at the moment we are still expecting for the next decision of ECHR on the compensation to some individuals. And even though we are saying that this decision is going to be at least in a few years, nevertheless, the court has given Ukraine, the Russian Federation, 1 year to provide the context, and it's going to be over in June. And I'm quite sure that the team of the Minister of Justice is working hard to fill in this list. But also, it's the question of the cooperation with NGOs to support the team of the Minister of Justice, but also to pay attention of the victims of in the Autonomous Republic of Crimea if there is kind of some violation, and these people have faced violations since 2014, 2022. Maybe there is a need to write something to the Minister of Justice because there are thousands of those who suffered, and neither NGOs nor the ministry can cover all of them, and therefore they have to write something, and we are ready to support them. And speaking of the perspectives of the implementation of this decision and what are the consequences for the Russian Federation. In this case, indeed, we have to understand that, yes, the Russian Federation refuses to implement this decision, and whether we want it or not, there is no mechanism to force them to do that because it depends on when the Russian Federation is willing to do that under the pressure or voluntarily, which is less possible, and that is something we have to take in account. If we are talking about Georgia, Sakartvelo, and the armed conflict which happened, and the armed aggression in Sakartvelo and the occupied territory of Moldova, where Transnistria was established, and also Chechnya case. And so far, the Russian Federation did not implement any decision. They didn't even pay the compensation to the individuals. For us, what does it mean? It means that there is a lot of work, and implementation will take a lot of time, but it doesn't mean that we have to give up because, in fact, these mechanisms are in place, and even at the moment, we can be using this decision with different purposes, not only to force the Russian Federation to implement the decision. And what is important in this case? In my opinion, this decision has to become something for the Russian Federation not to get rid of the sanctions, because we can say, okay, we forget sanctions, but you have to implement the decision of the ECHR. If you are not doing that, okay, sanctions are going on. So, for example, if we're talking about the frozen Russian assets, frozen assets can be also the particular something we can use in this case. Okay, you have to implement the decision of ECHR, and then the assets are not frozen. So that is the thing which will help us to avoid the situation when everything will be cancelled. And also from ECHR, it is also a good decision because the sanctions can be imposed and the assets can be frozen, not only when the violation is ongoing, for example, the armed aggression, but also until the moment when the compensation is not being paid back. And that is something that we have to make a condition. And I think that sooner or later we will return to the fact that the Russian Federation will say that I want to return to the Council of Europe because I'm a democratic country. Okay, so here the decision you have to implement of ECHR. And I think that is also important thing. And finally, it can be a separate block for the potential peace agreements which are discussed now, and the Russian Federation cannot be suggesting, so to say, in the peace decision, not in implementation of this decision, which Mr. Volodymyr and Mr. Alexander mentioned, because there's a final decision which cannot be cancelled, which cannot be which you can refuse from, and we can use it as a leverage that the implementation of the decision of ECHR can be connected to some certain conditions. And yes, indeed, we have to remember we are still waiting for the decision on the compensation. But I also would like to say that after the implementation, if I have all the time when the Russian Federation is not so there is an interest, the penalty for not implementing the decision and not paying the compensation. And on speaking of the perspectives of the fulfillment, we're talking about whether this decision can be implemented. So in this case, it is remembered to understand that some certain individuals, survivors, even though it sounds absurd, they have to try to require from the Russian Federation the measures, the compensation, the reimbursement on the grounds of this decision of ECHR, or they have to require the release of some certain people who are considered the political prisoners. It's also very important to do that because it's clear the Russian Federation might not be responding, might not be answering, but that is also the pressure which will be efficient. And also you have to write to the investigative committee of the Russian Federation. Let them be talking about, let them be telling how they are working. We are going to use it for our purposes because in the end we are coming to our international partners and we are saying, oh, that is an individual, the survivor, and they cannot say that there was no violation, no case. And that is also our fight, which is not only legal, informational, and we have to contribute to it. And what else is interesting we could have tried in this situation? In my opinion, for some reason, I think this mechanism is not that quite often used. But when one state refuses to implement the decision, the committee of the ministers of the Council of Europe has one more mechanism. They have contact the European Court to adopt the decision that the state has refused to implement the decision. And this way, they violated one more provision of the convention. So then you might have the question why you need this kind of decision if you can say that the main provisions are not filled in. But as you can see, there is nothing regarding Ukraine at the moment. Why not to do that regarding Crimea? And once again, we are still having Crimea in our informational focus. We are still there in legal, informational way. It's also very important, and I think that it's going to be a strong signal that this decision is regarding the Autonomous Republic of Crimea and regarding the Russian Federation. But I found a few cases, and they were only about the Republic of Turkey and some individuals. And it was weird to see no decision on Sakartvelo or Moldova regarding the occupation and illegal activities. So that is also the opportunity for us. What else is important in this case from the practical perspective? One story which is related directly with activities which have to be undertaken in the Autonomous Republic of Crimea, which is temporarily occupied, to release prisoners, and that are the things which depend on the Russian Federation directly. And compensation does not directly refer to the Russian Federation. Unfortunately, the history doesn't know the forced implementation of the decision of ECHR, but maybe we will be the ones who will rewrite this practice. And finally, we have today the register of losses, damages and losses in the framework of the international mechanism for reimbursement. Unfortunately, it refers only to the events after 2022, but in this case, there is an opportunity because we already are able to include the violations after 24th of February 2022, and it's covering this decision. But also, that's also the case that the Committee of the Ministers of the Council of Europe we have to suggest them to initiate some new mechanism and broaden this mechanism from 2022 to 2014. And there should be the separate compensational fund, which is going to be the source of compensation for the individuals. And of course, that is a huge question, how it should be filled in. But once again, we return to the issue, to the frozen assets. And here we are saying that there is a decision. So to say the decision that is not a criminal case, but nevertheless, the international decision which has to be filled in, and there should be some certain amount which has to be compensated, and we can say that the part of these Russian assets, frozen assets, they can go directly to these compensation fund to compensate the funds. So I think that it's an important block we have to work on. Well, briefly, that is how it looks like. And another thing which is important, if the Russian Federation will decide to implement this decision, which is not very likely, but why am I mentioning? Because in Sakartvelo's case, the Russian Federation even tried to answer the committee of the Minister of the Council of Europe how they are going to implement the decision. They translated the decision on Sakartvelo. They sent it to the Federal Service, to the Minister of Defense, to the Investigative Committee of the Russian Federation for them to find the ways to implement this decision. In my opinion, that is just the brainwashing, that we are kind of doing something. And I can suggest that they were just laughing at this decision of ECHR, but it means that we have to control everything. And if some provisions are not filled in, then the decision is not implemented. Okay, thank you, Mikita, for the skeptical, realistic perspective on the consequences. And I think that, in fact, it's very important. And we have to work on this. And because it refers to specific people, and every violation of human rights has the names with them, and that are not just the numbers, that are the people, and many of them are now in detention in the Russian Federation, and we have to return them. That is not just a matter of the property. That is not just the work of the religious organization and public organizations on the territory of the Autonomous Republic of Crimea. That is a big spectrum of range of activities we have to clarify, and we have to work together on it. And the role of the NGOs in this case is very big, because at some point all sides recognize that we need some sudden pressure on both the Council of Europe to identify the obligations of the Russian Federation, because so far that is the only decision where some solid decisions are made. What was illegal, what was legal, what violates the human rights, and what does not violate the human rights. It's not the publication in mass media. That is not the report of some NGO. That is not just the evidences of the people. That is a core decision. And that is why this mechanism is so important, because in this world, so to say, in the world where mis and disinformation are so spread, there are some decisions which identify some solid things, some solid obligations of the states, and therefore it is important for NGO to mobilize the pressure on the Russian Federation, that there are some certain violations. They are recorded, they are identified, and the Russian Federation has to implement the decision, because in the political dialogues it's quite often forgotten. And for example, the register of damages and losses, which started operating and which was established by the agreement between Ukraine and the Council of Europe, where Ukraine in fact agreed to have this register as it is now, and the parliament has ratified this agreement. For some reason, this agreement is not spread on all the violation of human rights since 2024, and we have identified that the Russian Federation does not have the mechanism of financial reimbursement to the individuals for the crimes they committed since 2014 till 2022. And I think that that is the mistake of Ukraine, because Ukraine is one of the signees of this agreement. We could have insisted that this mechanism should be working since 2014. And in fact, we have skipped this moment, and that is something we can change. There can be some additional agreements to this agreement on the register of damaged and losses. And we were trying to connect it to this decision, Ukraine against the Russian Federation, because it shows these problems pretty well. Why, since February 2022, these decisions are in the framework of this register, and before 2022, before February 2022, they are not in the framework of this register? There is no logics here, but once again, that are going to be the same violations which are identified even by this decision of the ECHR, though it didn't find the expression in the decision of the Committee of the Ministers of the Council of Europe, and we have to continue this global pressure. You can find the documents which we collected using the QR code. That is the decision of the Committee of Ministers of the Council of Europe in English. There is translation into Ukrainian language. Beside that, there is the application, which was the document applied by the Ukrainian NGOs with the list of the activities we suggested. It is in English, broader, and also there is Ukrainian translation, the recommendations which we're providing. Beside that, there is a general file which provides you more information about the content of this decision of ECHR and what kind of violations are identified by it, because we were not naming, we cannot name all the decisions, all the violations which are identified by this decision, because indeed there are lots of them, and this decision is more than 100 pages, and each decision of, according to the European Convention, they identified what kind of violations did what did the Russian Federation violate? And and if you have any questions or comments or feedback, you're welcome to ask them. We will deeply appreciate them. If you have any, please introduce yourself and ask your questions or comment. Please. First of all, I would like to thank you for this event. My name is Honcharenko Konstantin. I'm the representative of the Prosecutor General Office. I have the question. In the decision, it is said, as you said, illegal activities of judges and implementation of the Russian legislation. Could you tell us, please, since 2014 till 2022, for example, if there are the criminal proceedings, for example, by some certain prosecutor or by some regarding some certain judges, is it possible to find how, I mean, you can find the decisions of some particular judges or prosecutors where it is said that there is a name of the judges or the prosecutors? Is it possible to do that? Maybe you have the right information, maybe the NGOs have some certain information, or maybe you can tell us the way where we can find it ourselves, maybe open data sources where we can find these data. Let me start, and my colleagues will continue. So, partially it is open source data, and in fact, you can find the names of the judges, both in Crimea and the other parts, because that is an open order of the president of the Russian Federation. Maybe when it comes to the prosecution, then it's harder because they are not on this level. But nevertheless, we have the prosecutor's office of the Autonomous Republic of Crimea and Sevastopol, and they have Telegram and Facebook pages, and they are updating the information about the allegations, and considering the fact that many procedures are happening without people, so you can find the information about the cases. Some information can be classified or can have limited access, but you can find it. And if we are talking about the judges and the prosecutors, I can add that, for example, our organization, we are organizing and we organized the research on the demographic situation in the Autonomous Republic of Crimea, and we were taking the part of the information regarding the legal system and who were arriving to the Autonomous Republic of Crimea with their personal data. But that is once again the question of the information exchange and what is the purpose. And brief information. So in the context of this decision, the Russian Federation is responsible for this. There are not some particular people, and therefore it is more important to understand. For example, there is a statement of the ECHR about illegal activities of the courts, which are operating according to the Russian legislation. How deep we go in understanding of this wording. So does it mean that all the decisions which were made since 2014 till 2022, whether they are illegal, we have to partially accept it? For there are some general criminal crimes, for example, murder, theft, or for example divorce, or some other cases, non-political ones. And can we perceive these decisions as the ones which are meeting the requirements of Ukrainian legislation? And also we can be saying that political cases, for example, political cases, we cannot accept the evidences and the decision of the Russian court on some political matters, and we do not consider that it's the reason for us, and we do not consider this detention to be reasonable. But to make this line takes a lot of efforts, and we have to understand what should we require from the Russian Federation. And that is a problem for Ukraine, because we did not determine this policy on the occupied territories. For example, if at some certain point of time we get back some territories, how this transit justice works? We do not have this certain mechanism on how we work with the decision of these courts. And at least on the legislation level, we need some documents. We do not have even a political document which would have identified how Ukraine determined how Ukraine will perceive this court decision, or how, for example, we will work with the decision of the occupational government. For example, for 3 years we have the occupational government, and that is a problem we have. We have a political and legal dimension of this problem, and we cannot determine how we will perceive it, because before that we had the policy of non-recognizing of all of these decisions, absolutely. But then the obstacle is that for the people it creates some certain issues, because once again there are some certain general legal issues, for example divorce, death certificate, birth certificate, and the others. So how should we perceive all of these procedures? And therefore there is the room for discussion on how we can identify these obligations, but this decision should not is not binding for some certain individuals. It's more obligation. What we were trying to promote, all the countries, members of the Council of Europe, they have to undertake to efforts to investigate the cases of abduction, murder, tortures, and the other crimes committed by the Russian Federation, that they have to be investigated, and that we can recognize, we can understand who has to be punished. So we have to help the Russian Federation on investigating these violations, the thing they should have done themselves. So we are already talking about the transit justice, and the only thing I can add is that unrecognizing the facts which are happening on the temporary occupied territories since 2014, and documentation of these facts, that is one of the problems, because to identify these these violations, we have to legitimize them somehow. We can even take some example for example, returning from the territory of the Russian Federation to the Autonomous Republic of Crimea. We have to consider the documents, or for example, the document about release or some other document which has to be considered as the ones which are valid, which deserve to, so to say, analysis and legally confirmed. And we're not talking about the range of the documents. For example, the documents about education, the documents about labor documents, and the civil right, inheriting the property, and some other things. And there are hundreds of thousands of these kind of cases. So what does it mean? They will be reapproved or they will be recognized as invalid. So there are lots of challenges which we have to consider. But now we are moving a bit in a different direction, because in fact the implementation of the decision depends, the logics and the rights in the convention and the controlling monitoring mechanism of ECHR, which is according to the convention, and that is a goodwill of the state to implement this decision and the existence in the framework of the standards of the convention. The problem is that the Russian Federation has left these standards of the convention, and we are trying to understand how they can implement this decision, probably under some kind of in a forced way. And here we have to consider the practice which we already had. I know that the constant, the permanent decision, so to say, the decision which was not implemented regarding Cyprus case, Uizido case on the property, right? For a dozen of years, this case was not implemented, and that is regarding the Republic of Turkey, an occupation of the part of the Cyprus and inaccessibility of the territory. The Republic of Turkey refused to recognize their responsibility. And I'd like to remind you one case, the case of Ilyashko against Moldova and the Russian Federation. And in fact, it was something really offensive for the Russian Federation. How someone dared to blame the Russian Federation for the Russian Federation to be responsible for the political regime in Transnistria. And that was the first case when the Russian Federation was blamed for war crimes. But it was, so to say, ordinary thing. Illegal detention with tortures regarding the group of people. But the fact is that both Moldova and the Russian Federation are where the countries who this case referred for. And Moldova said that we are not able to implement our jurisdiction, and the Russian Federation said that they are refusing, and that was the first case when the Russian Federation refused to implement the decision. So, adding to what Mr. Volodymyr said, indeed, there is no direct correlation between the decision of ECHR and And as I already mentioned, that is not. So the ECHR has to determine the violation, even though they say that some certain countries violated the rules. But nevertheless, there are no names which you could use to punish them, because that is a task of the national criminal authorities and cases which are happening here. And moreover, it is also important to understand that mainly we are talking about the agents who committed international crimes, because just punishing the judge who in fact is doing the justice, why, how? And the other thing is that they are acting against Ukrainians, or when they are detaining them without justification, then it is different. And our And in this way, we narrow down and we understand what states that there are the real violations of the international law, and in this way we push the International Criminal Court to find the peak of this iceberg to get their punishment. So that can be an additional leverage which will be enhancing the argument, but once again it cannot be the grounds to sue someone. Thank you very much. Maybe other comments and questions? Olga Stukova, media window of reconstruction mediator. You said that we have to make the pressure from the civil society. Maybe you can provide us with some recommendations what the ordinary civilians can be doing who are not the specialists. Should they be doing something, and what can they be doing? For example, there can be a flash mob in the social network. So, I mean, is it a kind of prerogative of the NGOs which have some certain specialization on human rights or on the temporary occupied territories? Well, I think that first of all, it's more the question to the NGOs, because in this case we are talking about some certain people and data collection about the people who can be qualified as survivors, victims in this case. So, for example, all the people who are in detention, all the people who were detained, what kind of property they were deprived from. So the state authorities are doing this work, but I know that there is, so to say, the field, the room for cooperation. And therefore, it's more for the NGO, because for the state authorities it's quite difficult, it's quite complicated due to the limited resources, due to many different reasons. So that's not a simple process, because the violations which are happening in Crimea, there are lots of them, and it's hard to create the list, and it will take years to create it. And when this decision was applied, when we were preparing the documents for the ECHR, NGOs were providing a lot of information. They were collecting during the monitoring visits since 2014, and they were traveling, and they were providing this information to the Minister of Justice, and that is the reason why this ECHR decision is quite detailed regarding the types of the violations, because there is the story behind each of these provisions. There are the facts which we are provided to the ECHR, and they saw that it's not just a constatation of the fact that there were illegal court proceeding in Crimea, or like when people were deprived from the right for their property. There is a list of people who lost their property, and it was sent to ECHR, and ECHR was considering each case. So in this case, it is very important to have on the individual level individual measures, and to have the list of people behind these provisions, because once again I would like to underline that for these people that is the only possibility to get some financial compensation, because once again the register of losses does not cover these expenditures. So if it's going to be, so when we are talking about satisfaction and the fact that the Russian Federation has to compensate these losses, I think that is quite a useful mechanism, because on the one hand, that is the state has to undertake some measures, because that is also the detection of some losses. And since 2014, it should have worked on the national level. That is also the issue that just recently we have the law adopted on the damages and losses on the newly occupied territories. So speaking of Crimea, there are some certain issues, some certain problems, and we have to try to organize in the future, in the near future, the round table with state authorities and NGOs, and there are lots of linear organizations which will join us, because there is lots of work to be done and to collect this information from the people, because in fact it's not the initiatives we need from the people, but the initiatives from the NGOs and from the state authorities who know how to do this systematic work. Maybe I will add a few more things. I would mention that at the moment we have the cooperation with the Minister of Justice and additional, so we are working on the compensation to people, and of course we have to identify these victims. And as I would managed, it's hard to identify each and everyone, especially when the people know that their rights were violated and they do not contact anyone. So you have to inform them that your rights were violated. How you can do that? You can contact the law enforcement officers. Typical thing, if we're talking about military cases, that is state security service, and now it is enough to contact on the level of the prosecution, and they will redirect. So the main thing is that you have to contact and to explain what has happened. If you have the feeling that the person cannot prepare the legal position, but that is, once again, that is you have to talk to the person. There will be the communication with the person to understand what has happened, but also you can contact the NGOs, which will help to collect the data to prove the case and to prepare the documents as well. And also, if we're talking about the register of damages and losses, but that is just for the future. If they expand since 2022 to 2014, in this case, people can just open the app and they can register themselves. And it's better to have at least some small legal consultation to provide all the legal documents, not to have the issue that there is no justification for this application. Appeal. And even though we are talking about the decision on Crimea of ECHR, I think that is important to remember that there are still the mechanisms for the survivors, and you can contact with. So that is the UN committee where you can still contact with the same individual cases regarding against the Russian Federation. The only thing is, of course, if 5 years passed since the period, it's too long. But I think that some of the things can still be covered by this period. So we have to continue our work to open the cases against the Russian Federation, and in the future to be. Maybe to get the compensation, not only in the ECHR, but also by the other institutions, which suggest lots of other legal mechanisms. But I can agree with Mr. Vladimir that in the context of this decision, of the current decision, that is more the work of the NGOs and the state authorities to accumulate this information. The more precise, the better possible. But nevertheless, survivors have to identify themselves. That is me, that is a violation. Maybe I have to be included in this list. Thank you very much. Maybe you have the other questions or the comments. Thank you. My name is Alexandra. I'd like to ask something, a long-term perspective question, maybe something theoretical regarding the fact that, yes, indeed, when developing the strategy, and you've mentioned the transit justice and satisfaction reparation, that is also the transit justice, but another mechanism of the transit justice. Do you consider it worth adding them to the strategies of the implementation, or maybe that's another direction which has to be supplementary? Or do you think you're more about the narrow decision or interdisciplinary and comprehensive approach? I was silent and I was given the mic because of that, but I was working with the transit justice, and I was working on the strategy of the transit justice, which was prepared to be shown. And so when we are talking about the transit justice, indeed, these elements, so which we're mentioning, we have 4 elements, but one of them is the responsibility for, so to say, crimes committed accountability. So in this case, we have it. The other elements, they are also there when it comes to the general activity. So monitoring, so not returning to the situation to recover the legal jurisdiction, Ukrainian jurisdiction, I mean the Autonomous Republic of Crimea in the framework of this decision. And yes, indeed, it refers to the transit justice. The question of memory, I think that is a separate question, and we have to be speaking about it. So the question of the transit justice is more directed on the work on the territory in the post-conflict period, when the conflict is over. The question of the implementation of the ECHR decision is in the dimension of the political and legal resolution of the problems violated by the convention. So in fact, we have the tool, the convention as a tool, and through this lens we perceive the situation, which led to, by the way, what is the novelty in this decision, recognition of the fact of the serious violation of the international humanitarian law and criminal law. And quite often it is mentioned that there should be prosecution and punishment of those who enabled it. So in fact, there is a requirement to bring to criminal justice those the perpetrators, which is typically not mentioned in the decision of ECHR, the perpetrators who have committed the war crimes, because the level of these crimes is the level of the war crimes. But answering the question on how it correlates and if it is possible to have the strategy of the transit justice, and can it be in the plan of actions of these decisions. So far, we do not have the strategy implementation of it. There are just the general drafts. The action plan, as we've said today, before our meeting, our application of the NGOs, that was the hint how to build the action plan and how this decision has to be implemented. Once again, I'd say that lots of things depends on how possible it is to implement the decision, and that is the pragmatism which we have to have in the decision, and that should be the key factors. I'd like to add that there are some certain elements which are on our side. For example, that is a decision which identifies clearly that the passportization is the violation of the human rights, and that is a perception that is a perspective that is our perspective. How we have to consider it. So there are the calls to refuse to give back the Ukrainian passport for those who accepted the Russian passports, or there are like legal responsibilities. So there are different approaches how to assess what is happening at the moment. So the decision are qualified in this way. How to qualify what is happening going on now. So it has to affect our policy and regarding the reintegration of these territories, to understand what is collaboration, what is collaboration activities and illustration, and the other things. So that is the matter which has to be discussed and will affect these issues. So because if the European Court says that the passportization is violation of human rights, we cannot be punishing them for the person taking this passport, because this person has no other option, and there are no mechanism, and therefore maybe that is the difficult political decision, but it is going to meet the standards of human rights. So as we already mentioned, of course, in the measures we were suggesting, more or less, there is the transit justice, and that is a question of the responsibility, what we've mentioned already, the compensation, the question which has to be resolved by the court, and we were suggesting the compensation mechanism on some certain cases, and also it's quite hard because that's not the role of ECHR, but this adoption of this decision and the participation of the NGOs suggesting their decision to the Committee of Ministers is an element. It can partially be the element and can be showing what has happened on the official level because that is a decision of ECHR. But when it comes to reintegration and peace, well, we understand that. In this case, we're talking about the implementation of the decision by the Russian Federation. But in the end of the day, it is the question for Ukraine what to do on the occupied territories, how to fight, how to counter the 10-year propaganda, the consequences, who has to be punished and who not. So all of these depends on Ukraine, and therefore it cannot be reflected in the decision of the committee of the Council of Europe. But no, and all in all, we are using that. But developing the strategy of the transit strategy, it's impossible, but it refers to the Russian Federation, and Ukraine can do nothing with that. Thank you, Mikita. Unfortunately, our time is running out, and therefore, I would like to thank you. I hope it was interesting for you. If you're representative of the NGOs, please join us because here we have lots of work to do, and there is a lot of work ahead, and because that are the things which are out of the political scope, and neither Trump nor the other president can cancel them, and that is important because sooner or later this decision will be there and it has to be implemented. Thank you very much for your attention, and